distinguishes between a right that your daughter may have and your son may have, or your wife may have, or your sister may have, and your brother may have, that the Supreme Court should engage in heightened scrutiny, not just look and see whether or not it makes any sense, but take an extra special look. You and I know the terms, but the public listening here. The Supreme Court has said since 1971, when a state passes a law that treats in any way a woman different than a man, there may be a rationale for it, but the Supreme Court is going to take a very close look. Not strict scrutiny, which means you can hardly ever get over that bar like race, but you take a heightened look. They're going to look at it more closely. Do you think that needs to be done? The Constitution calls for that?
Yes, Senator, I do, and I, again, always have. The confusion is in the use of the term. There are those who use the term heightened scrutiny to refer to what you just called strict scrutiny, which is generally limited to issues of race or similar issues. The discrimination on the basis of gender, distinctions on the basis of gender, is subject to what the Supreme Court has called intermediate scrutiny. There has to be a substantial government interest, an important government interest, and a substantial connection in the discrimination. But the Supreme Court's equal protection analysis has 3 tiers now.
Well, I understand. My time's run out. I'd love to hear the explanation of 3 tiers, but let's stick with this one for just a second. Then explain to me what you meant 10 years after the decision, laying out this level of scrutiny. When you wrote an 81 memo to your boss, you wrote that gender, quote, is not a criterion calling for heightened judicial review. What do you mean referring to what you called strict scrutiny? You didn't know the difference between heightened and strict?
Well, I was about to lay it out. You said you didn't want to hear about it. Strict scrutiny is the...
No, I know what that is. I wonder what you meant.
Senator Biden, let him finish his answer.
But I have no time left, Mr. Chairman. I understand the answer. I understand that the Supreme Court has 3 levels of scrutiny. My point was in the context of this memo, in the context of this memorandum, the question was whether or not the court should, in fact, have a heightened scrutiny. And, Senator, the memorandum is using heightened scrutiny the way you use strict scrutiny, which is the scrutiny that's limited to the basis of race. The gender discrimination is, as you know, subject to what's called intermediate scrutiny, right? And that is not what the memo is referring to with respect to heightened scrutiny. It's referring to the strict scrutiny that's restricted to issues of race and ethnicity. Well, I'll come back to that in the second round because that's not my reading of what you said. But let me get on another issue here. Again, in the sex discrimination area. The Attorney General for Civil Rights